Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and I guess, warm hello to everybody in between. As you can see on the screen, my name is Dan Balkaran, and I'm an employment lawyer at Samfiru, Tumarkin LLP, Canada's leading employee-side employment law firm. Before we get into your questions, just a couple items of housekeeping. As always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so while we're waiting for the questions to come in, you guys had great questions last week, and certainly we hope to have some of them again today. I just want to, there've been a lot of layoffs happening in different sectors as the economy seems to be moving into, unfortunately, a downturn. I don't know if that's true, and that's certainly not where my expertise are, but we are seeing a lot of layoffs happening in different sectors, not just in technology. And I just wanted to talk about that for a second just to underscore a couple things. So the term layoff is not a helpful term because it means something different to different people. And so a temporary layoff is an interruption of your employment where you're not getting paid, but you retain the right to return to your position by a finite date. So there'll be a statutorily prescribed date after which your employment, if you choose to do so, can be considered to be terminated. And why you'd want to do that is if you wanted to pursue severance, your severance entitlements at that point in time, which again can be quite lucrative for some people. It's as much as 24 months. But that's what a layoff is. It's a temporary interruption of your employment with a finite end, usually. And so quite often people are put on a temporary layoff and then they're returned to work. And if your employer says, we put you on layoff, but before the statutory end of your termination date, we recalled you to work, generally you have to go back to work. There are some limited exceptions, but generally speaking, that's what you have to do. But for many of the public, and for employers, layoff means permanent termination. And so it can be a little confusing as to what that is. And so if you've been put on layoff, you need to understand what the distinction is. If you are not returning, your employment has been terminated and you have a severance entitlement. And what that is can vary greatly depending on what your employment contract says, if any, and then your age, length of service, and the nature of your position. But you want to understand what that is. And if you have been put on permanent layoff, you're going to have some sort of severance entitlement, and you're certainly going to want to talk to a lawyer to find out what that is. And as always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, let's get into the questions. Question from Romero. My employer terminated me because I developed Parkinson's and I can no longer work efficiently. Can a medical condition be a for-cause termination? No. I mean, the short answer is no. So, I mean, the first thing I want to say, Romero, is I wish you very good health as you take this on, and I wish all the best to you and the best outcome that you can have given the situation. So I'll preface what I'm saying actually, or what I just said a little bit, or I'll add some more context. So generally speaking, you cannot lose your job because of a medical issue. Okay, and so all across Canada, if you're federally regulated or provincially regulated, there'll be a human rights legislation that says you can't effectively be discriminated against because of a medical issue. And so certainly, your diagnosis of this illness would certainly qualify. And so generally speaking, in such situations, yes, you'd have a severance claim. And again, the severance claim could be quite substantial, but you'd also have a human rights complaint, which can assist you with getting even additional compensation, we'll say. And there are a lot of, interesting strategic and jurisdictional questions around a matter when you have a human rights complaint and also a severance claim. And you're certainly going to want to talk to a lawyer to assess all of that and assist you in pursuing your maximum compensation for losing your position. However, I will say it's subject to a big caveat, and that is if you simply cannot perform the work that, because of your medical illness, that you normally would do in your position, there is a possibility that your employment could be considered what's called frustrated, and your employer wouldn't owe you any severance. Basically, all rights and obligations under the contract are extinguished. Usually, that's reserved for a situation where you're totally disabled from working for a long period of time with no hope of being able to return to work. But it comes into, and under the human rights regime, there's an obligation to accommodate. The employer has an obligation to accommodate you to the point of undue hardship. But where that is in terms of efficiency is certainly the subject of a lot of we'll say claims and disputes between employers and employees. So, if you just simply can't do your job anymore, as opposed to doing your job, say, at 80%, therein might be the dispute between the two parties. So, Romero, more than anybody, I'm sure that I'm going to talk to today, you need to talk to an employment lawyer. You need to do it right away. And certainly you should, if you want, you can contact us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. And again, Romero, my best wishes and all of our best wishes go to you as you deal with this medical issue. Question from CJ. My employer changed their policies, while I was off on medical leave due to an injury I sustained on the job. The policy limited the number of days you could be sick or late to 3 in 6 months. And because I needed to take time off for medical appointments, they let me go. I worked there for 20 years. Is there anything I can do? Yes. I mean, it's mostly the same information I gave to Romero, regardless of whether or not you have a severance claim pursuant to whatever your employment contract says. You certainly have a human rights complaint, and you can pursue lost wages and potentially injury to dignity damages at the same time. You should 100% talk to a lawyer right away, CJ. And again, I sound like a broken record. You can contact us if you want at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But yes, no, if what you're saying is accurate, if you had to go to medical appointments because of a medical issue that is, we'll say, papered by or supported by your GP, no, they can't let you go because of that. So, and if they did, then they discriminated against you on the basis of disability, and you certainly would have a complaint via that route, and potentially a whole host of other remedies. So certainly you want to talk to an employment lawyer right away. Okay, this is from Frank. It's out of order, but I'll see if I can sort this out. As the president, the highest ranking executive, apologies. As the president, sorry, I'm just trying to get some things off my screen here. As the president, the highest ranking executive, do I need to give notice when seeking medically advised stress leave, especially without an immediate replacement, considering my employer's location in the United States? Okay, so if you're going on stress leave, you have a medical condition backed by your doctor, medical provider, psychologist, psychiatrist, whomever, that says you have a condition that necessitates that. But if you're asking, well, hey, can I postpone that for a period of time that the company needs? But then by definition, the leave you're going on is due to a medical issue, which needs to be attended to immediately. So I don't think that you should stray from the nature of what your doctors are telling you, not just from a medical perspective, but also because then there's an argument that, if you can postpone the thing that the doctors are telling you, maybe it's not a necessary thing. I mean, if it's properly papered by your doctors, I don't think it's going to matter anyway. But the larger question here is, if you're the president, what degree of coordination do you want to give with respect to the business and your absence? And I don't know if this is an open-ended thing. I don't know how long. Like, are you talking about going on for a week, or you could be away for 6 months? I also don't know. You're president, you're the top of the heap, and you're answerable to the board of directors, or are you answerable to nobody and it's your company? Like, I just don't know. Don't have enough information. I will say, at the very highest levels of businesses, um, there was certainly a very heightened expectation on C-suite employees, and certainly of the president. And I think that there were certainly, you were smart to be alive to this, but I think that there, and again, I don't know, are you answering the board of directors only, and what the structure of the corporation is? But certainly, there's going to be some concern around your absence, and I would be cautious. Cautious, not the right word. I would be rigorous in trying to ensure that you retain your position through this absence, we'll say. Okay. And I think that's strategically could be complicated. And so I mean, again, I sound like a broken record, but I think you're going to need a lawyer to guide you on this one potentially. So I think you may wish to talk to an employment lawyer. Again, if you want to talk to me, you can, or talk to us. Sorry, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. But I will say, Frank, given your position and the limited information I have, you're right to be alive to your concerns about your viability there, and I think you need to handle that very carefully. But if you've medically got to go, then you've medically got to go, right? So, generally speaking, I will say that there are different types of medical leaves, and in my experience, employers aren't big fans of stress leave. And when there is a quote unquote stress leave, I've seen many times where eventually that employee is not there anymore at that employer. The employer figures out a way to get the employee out of there, pays the severance, what have you. So it's different than you suffered a physical injury or you had a cancer or something like that. It's treated differently by a lot of employers. So and what I was saying to Frank is that the focus on employees at the very highest level, or the expectations of them are different, right? And so I think Frank is very wise to have asked that question, and certainly I think he needs legal advice as he goes, but he's also got a situation where he's got this serious medical issue and needs to attend to that as well. So it's complicated for sure, but I just wanted to put that out there, and this is just my experience with companies and stress leave. So Ash says, if you've been terminated for cause for false claims from your employer, how can you go about claiming a wrongful dismissal? Is it my word against theirs only? Okay, well, this is a great question. So, and this is actually many just cause allegations. So just cause simply means that an employer is justified in not paying you any severance whatsoever. It's the capital punishment of employment law. And so quite often it features a disagreement, a battle over what happened, battle over the facts, we'll say. The employer says, so-and-so, this particular employee committed time theft on a massive scale. And the employee says, no, I was following directions of the company, working in this other area. And there'll be a dispute over the facts. So, quite often cause allegations turn out to be not enforceable at law, we'll say, or at least not successful. And so just because you've been terminated for cause does not mean you're going to get nothing. But those are complicated cases, and I can't give you specific advice, or I guess we'll say a specific impression, Ash. because I don't know the facts of your situation. And so I don't know what's been claimed and what's not. But I will say, broadly speaking, with just cause, because it is the capital punishment of employment law, the employer has the burden to prove it was justified in terminating for just cause. It's a steep burden that is on the employer. The law doesn't want you to get nothing. It doesn't want you thrown on the street with no money and no job. But if you committed theft or fraud or punched your boss in the face or were doing drugs at work or something like that, or committed an ongoing series of performance failures which you were provided clear written warning of, and you didn't fix them, then certainly cause can be made out. Anyone who tells you that they know how any specific cause case is going to turn out is, I'm not going to say lying, but is wrong. It certainly turns out on the facts. It turns on the facts, but it really turns on how the judge assesses the facts and the credibility of both parties. And it's each individual cause case is unique. And so there's risk to both the employer and the employee on cause cases. And generally speaking, that leads to compromise between the parties, but not always, because there's often bad blood when there's a cause allegation. So all of which is to say, Ash, you're not without hope, but it depends on the facts. And so you could have a great case, you could have no case at all, or very little case, but you got to talk to an employment lawyer. You have to do it right away. If you want to talk to us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay. Raj asks, any disadvantages of negotiating the severance package on your own versus going with a lawyer? Any issues if you need to move to a lawyer after trying to negotiate first and it didn't work out? This is a great question. I'm really glad you asked. So, generally speaking, people and employers don't give you money commensurate with your entitlement out of the goodness of their heart. Okay. They give you that money because of the threat of future financial pain, of having to pay more money down the road. And that's what a lawyer does. A lawyer can access the legal system in a way that you can't, which means that the employer has to pay fair severance value commensurate with your legal entitlement and a variety of other factors, or the employee through the lawyer will bring the employee's matter to court, get a judge to adjudicate it. The judge will then award a fair amount of severance, commensurate with what the termination entitlements of the employee are. And the employer will have to pay their lawyer a ton of money for the pleasure of doing so, of going through that process and having the award awarded against him or it. Okay, we'll say. So, the average person can't do that unless they are also a lawyer or have legal training. They don't have access to the employment system or the court system in that way. And so, employment lawyers generally can get I won't say awards, but awards or settlements, generally speaking, on a much larger scale than you can do it on your own. So that's one, and that's just a fact of employment law. Number two, you asked any issues if you move to your lawyer after negotiating yourself first. Yes, huge issues. This happens to me, once a month, where I'll speak to somebody, and then some person will take the information I gave them and try to negotiate on their own, and in doing so will dramatically harm their case, such that when they come to me, their case will either be significantly harmed or actually just not viable anymore. Employment law is incredibly complex. It's incredibly complex. And so you might be able to negotiate it on your own. And there's certainly situations where I tell people I speak to, yeah, you should negotiate this one out on your own. But if you attempt to go it alone, you may compromise your legal position such that, I can't fix it afterwards. And so you got to be careful with that. So, I don't know what your situation is, Raj, but generally speaking, in my experience, it's better to have your lawyer negotiate on your behalf from the beginning than you attempt to do it on your own, and then potentially compromise your legal position. This person does not have a name. Actually, I think it might be Justin. If a medical note an employee submits is questionable in quotes, is an employer allowed to ask the doctor to confirm they signed it? Well, I don't know what questionable means. I don't like. Is it a forged note? Generally speaking, the employer should not be contacting the doctor. The doctor's not going to be able to say anything anyway. Generally speaking, I think if the employer, like if the note is forged, I think you're in a lot of trouble. If the note is not forged and the employer is claiming it's forged, I think that employment relationship is very close to being over anyway. And you may want to consider working somewhere else, looking for a job and moving somewhere else, or if you have a potentially good severance entitlement, talking to an employment lawyer first and figuring out an exit strategy that maximizes your severance return, we'll say. But I mean, nothing can really stop an employer from contacting the doctor, but the doctor's just going to say, I can't talk to you about one of my patients. So, but again, if that's happening, I think the relationship is pretty close to over for any of those items that I talked about, either if it's a forged note or an allegation of a forged note. If that's what you mean by questionable, if you want to add some more detail, I might be able to assist further. Sally asks, I was recently let go and my employer has given me 7 days to sign and return their offer. It's not enough time to speak to a lawyer. Is there anything I can do about this deadline? Well, certainly it is enough time to speak to a lawyer, depending on how busy the law office is. But you can ask for an extension. If they won't give you one, then you have a problem. But you should always take an offer and evaluate with a lawyer whether or not it's fair and reasonable. Lots of times, you'll get an offer of the Employment Standards Act minimums, and the claim is worth 10 times that amount, or maybe not 10 times, but a substantial amount more than that amount. So, 5 times, 6 times, 7 times. So certainly you want to talk to an employment lawyer if you can, and generally speaking, you can ask for an extension. But if they don't grant you one, you really need to get legal advice on that sooner rather than later. There's a lot of questions about I don't know what that is, and I'm just going to ignore it. Yeah, for all the people asking about Alan Sugar's post, I don't know who that is or what that pertains to. I'll just say that this is a live stream to discuss employees' employment law issues and questions about employment law from an employee-focused perspective. That's me on the screen, Dan Balkaran. I'm an employment lawyer at Samfiru, Tumarkin, LLP, answering questions. So for all of those people who just jumped in asking about whoever this Alan Sugar is, I don't know. You may be in the wrong place. It may be something that I'm simply not aware of that happened just recently. So, but that's who we are, and that's what I'm doing right now. Raj asks, if you're terminated without cause a few months after reporting harassment by your boss to Human Resources, how much additional damages do you get apart from the regular severance for tenure? Well, I mean, if your termination was discrimination on a human rights protected ground, like if you were sexually harassed, then certainly you'd have injury to dignity damages that were extra. If it's a retaliation situation, you might be able to, just because of the optics and the equities of your facts, you might be able to squeeze out a little bit more money. you might be able to, if the behavior of the employer was truly egregious, you may be in line for punitive damages, which can be a small additional amount. So, it depends on the situation. Certainly, you're going to want to talk to an employment lawyer. I will say, generally speaking, those amounts are small, although there are some creative things you can do with them. And you don't have a strict compensatory entitlement to them, but you can obtain them in certain rare circumstances. So I'll just say that. But Raj, you need to talk to an employment lawyer. You're the same person who asked about going it alone, and then now you're asking questions about complicated reprisal terminations. After reporting your harassment to human resources. I think you need to talk to an employment lawyer, and I think you need to do it before you start engaging the employee. At least do it so you have some advice on your position. If you decide to go it alone at that point, at least you're doing it with the benefit of advice. And so if you want to talk to us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Yes, for all of you asking about Alan Sugar, he is not on the stream. I don't know who he is. Alan Sugar is a billionaire from the UK, and he shared this stream link. Well, okay. No, I maybe he has an interest in employment law, or maybe it was an error. But for all of the Alan Sugar people looking for Alan Sugar on this particular stream, this is an employment law live stream answering questions about employment law issues in Canada. So. All right. So yes, no Alan Sugar to answer that question. Okay. We might have time for one more question. Computer might actually die. I hope it doesn't, but we're pretty much out of time, and I've answered all your questions today, but let's see if I can get these last couple finished. So this is a unique name, so I'm not going to say it. My employer has changed my commission structure, and my monthly salary has decreased by compensation has decreased by about 11%. Are they allowed to make this change without my permission? Well, if you don't, so 11% is a little iffy, but generally speaking, if your employer unilaterally reduces your salary by more than 10%, it has in effect breached a fundamental term of your employment such that you can claim constructive dismissal. That just simply means the actions of the employer fired you by lowering your wage. Okay. Why would you want to do that? Because you'd be pursuing your severance claim. But if you do it, you no longer have a job. I must be very clear about this. Do not trigger your own constructive dismissal without a lawyer. Those are very complicated cases. It is too hard. I mean, you can voice your objection if you're very upset about this reduction in your pay, but you need to talk to a lawyer right away to find out, to get your strategic options, and then decide from there. You can reach us if you need to at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. And I will just say this to you: you have 2 months from the date of your termination, the date of the reduction, to claim constructive dismissal, after which time you're deemed to have accepted the reduction. So you've got a finite amount of time. You need to talk to a lawyer right away. Okay. And I know I sound like a broken record today, but you need to do that. All right, listen. Okay. Last question. My computer might actually die, but let's see if I can get this done. What should I do if my employer refuses to accommodate me and I'm with the union? You need to talk to your union representative. And if you don't, if your union representative won't help you, there are some lawyers who practice in that area. Very few. You need to get a referral to one of those lawyers to see if they can assist. But generally speaking, if you're in a union, you need to talk to your union representative. And I certainly can't give advice in that area. That's it. Join us on Monday. With, there we go, Chris Justice on October 2nd, 1:30 p.m. Eastern Time. And other than that, I thank you all for joining. Sorry about the no Alan Sugar. I'm certainly going to look that up now. But for everybody else, you had great questions today. I wish you a wonderful and safe long weekend. And we look forward to seeing you all next week. Have a great day.